Good evening, everyone. Welcome to the Immigration Talk Show brought to you by Sakshi TV. My name is Ranjit. We are with the attorney Prashanthi Reddy today to discuss the latest updates on second round of H-1B lottery, immigration updates, and frequently asked questions on H-1B and other visas. You can call the numbers displayed on the screen and ask any question related to immigration, and the attorney will be glad to answer. We will be taking calls in about 15 minutes. Before starting the show, I would like to repeat the disclaimer. Please note that this show is not intended to provide any legal advice. It is very general in nature and is only for informational purposes. Sakshi TV, our agents, are not responsible in any way for your actions. So please use at your own risk. Hi Prashanthi Garu, how are you doing?
Hello Andy, how are you, Ranjit?
I'm good. So yeah, a few things happened from the last week, and we can start with the latest that happened. I think USCIS just gave a notification that I-9, for the I-9 purposes, the H4 for the H4 EADs, I-797 approval can be used instead of EAD cards because there are lots of delays in EAD cards. So they gave this announcement just a while ago, I believe. Do you want to update about it?
Yeah, so yes, this is pretty much fresh off the press. It's very recent update. It's from today, a few hours ago. So as I had mentioned in the previous programs, that there are many lawsuits being filed, and there is a lawsuit filed specifically because the H4s are getting approved. H4 EAD 765 applications are getting approved, but the actual EAD card is not being sent. There's so much 6 months delay just to send the EAD card, the actual card. And as per regulation, unless you have the EAD card, you cannot start working because you have to fill out, the employer has to fill out an I-9 form. And as proof that the person can work, the proof is the EAD card. So when AILA, American Immigration Lawyers Association, met last month, we were discussing amongst ourselves that, even if the H4 EAD card is not there, we can just work with the EAD approval, the I-765 form. And we were advising clients to fill out the I-9 applications using other. There are several options for the I-9. And if you don't fit under any option, you can use an option called other. So we were telling them to use other and upload the 765 approval and start their payroll, because difficult times cause because of the times that we have to find creative solutions. So that's what we were doing. But luckily I heard today, as you were saying, that pursuant to a lawsuit that was filed, USCIS has updated their website. I haven't looked at it yet, but I believe they have updated their website, and they have said that I-7 actually officially I-797 approvals can be used in lieu of the H4 EADs. So that is very good news.
Okay, so do you think this is because of the lawsuit this happened, so that USCIS will not be sued by any other beneficiaries or lawyers, so they are on the safe side?
It's always, USCIS is only being reactionary nowadays. They're not doing anything that will benefit unless they're forced to do it, unfortunately. So yes, it's obviously because of the lawsuit that was filed.
At least it's good news for a lot of people. I know a lot of people are waiting, and a lot of people lost their jobs because of
Correct.
EAD cards. Especially,
Correct.
I heard that it's taking 2 months or 3 months since USCIS has, I believe, they have terminated the card producing company or something like that, and they've taken it in-house.
Right. So what happened in March is, just before the COVID started, they had contractors, and they fired those contractors that they used for production of green cards. So green cards also are not coming, by the way. So the green cards and the EAD cards, the contractor that they were using, they fired them, and they wanted to hire a new contractor, maybe less money. I don't know what the logistical issues were. And then COVID happened, and they just didn't bother after that. So they're pretty much operating without anybody to produce cards, which is a ridiculous situation to be in. COVID or no COVID, there's no reason why this cannot be sorted out. So obviously people have filed lawsuits, and as a result of which, they have at least given this concession.
Good to know that. And the other thing that happened last week after our, the last show was there was a second round of H1B lottery as we expected, and we also anticipated the same in the last show. So do you have any update on it? Like, do you happen to know firsthand that your clients or anyone has got picked in the registration and they got notification emails or something like that?
Yeah, so I think we got another 10% approvals. Not a lot, but 10% more when compared to the total that we got last time, about 10% more. And we received several emails, and this is a complaint everyone is having, and it's becoming a little difficult to figure out which ones are the new picks and which ones the old picks. So you have to go through the whole list. So they have not made it very easy to use or user friendly. So they're sending, and also they're sending out duplicate emails. So every time we get an email, we are thinking that there's a new case that was picked, but that's not true. They're just sending out duplicate emails, and the number of cases picked are still the same. And each time for us to go through and see if there are any new picks is taking a long time. So this is something I wanted to share with the audience, that the logistics of it hopefully will be improved for next year.
Their system is not stabilized yet.
Yeah, it's not. Whoever the IT folks were who worked on it, there should have been a way of showing new cases versus previous cases, which there isn't. But it's good news, because a few more people have gotten a lifeline, right? Especially people whose F1 is expiring, OPT is expiring. They don't have to go back to school. They can start working on a H1. So that's definitely good.
And also, I believe this is kind of first time in, I think, probably a decade or so, because I believe this never happened since 2008 or
That's true. It has never happened where they've reopened the cap again. This is all part of the new H1B registration process, I think, because they're able to actually track in real time how many applications are not being filed. Otherwise, before until the whole thing was over, they were not able to track. So it was, and then the next year they cannot again open the cap. If the year is over, that's it. It's over. The fiscal year, which is in October.
Yeah, so a lot of applications probably every year were wasted because of not having this kind of process.
Not having a proper process to track. Now it's immediately, so because there's a deadline to file even the H1Bs, and because you can immediately see the number registered, you can immediately see the numbers not filed. Previously, there was no such numbers. The only cases that could be recuperated into the system is the cases that were denied.
Okay.
So the cases that were denied, when it was not happening immediately, because premium processing also wasn't there for cap cases.
Yeah, at least from last 2 years.
Yes, yeah. So even that was taking a long time. It was going into the next year until you actually got a response to that. So they were not able to recapture the numbers. This year, because of the different system that they're using, they're able to recapture and see how many H1s are actually being used. Of course, the denied cases still they will not be able to recapture, because the denials may not happen this year. They may happen next year. So, at least something is better than nothing. The 10% is not bad.
True. And another question, a lot of viewers and even I have the other question is, will there be any chance of having another lottery? Because people may even still not have jobs, and few may not be able to file the petitions because of this COVID, a lot of layoffs or whatever, the position may not exist now. So there could be a possibility that even, let's say, 1 or 2% of applications they may not be able to file. And will that result in having another round of lottery?
They might not, because they have until November to file the application. So it might end up being next year, and they will not be able to recapture. It'll be too late to have another round of lotteries, because they won't know whether they're going to file or not until November, because November is the deadline to file. So I doubt they will have another opening. They might. People have been asking if this is it, or they're going to get any further emails. I think the last email we got was this weekend. But the major cases that we got were on that day that it opened up. After that, pretty much it's been duplicate emails. So I think they have, there's no reason for them to stagger it. I think they have sent us, the cases that they wanted to reopen.
Okay, sounds good. There is a lot of questions again, especially in these COVID times, offline in our social media handles. So I would like to go one after the other. One of the questions a lot of people have is the severance pay, especially when there is a job loss, you get 60-day grace. So a lot of companies provide severance pay based on their experience or their tenure with the company. So let's say someone loses a job, and after losing the job, he had got like a month or 2 months, sometimes even 6 months of severance pay they get based on the tenure. So do this severance pay counted against the status? And let's say if they have 2 months of severance, will the grace period start after 2 months, or is it just the day you lost the job is the day you have to start counting the grace period?
Yeah, so that's a good question. The severance pay is only severance pay. Basically, so as per the 60-day grace period, you have to start from the day that you were laid off or you left the company. It's not the day of the last severance paycheck. So that's pretty clear as to when the 60 days grace starts. But what happens is a lot of people will use, because proof, USCIS will ask for proof of the last day, and proof is usually a paycheck. So people will submit severance paychecks as regular checks, because not every time will it be written on that it's a severance paycheck. Sometimes it will come up as a regular check. So people use that as proof with USCIS.
They might get lucky.
They might. I'm hoping that they'll get lucky. So that's what it is. Yeah. But otherwise, it's just.
Sorry to interrupt you, Prashanti. We have a caller from New Jersey, Rakesh, I believe. Hi, Rakesh. Welcome to the show, and you can ask your question.
Hi. Like as you are familiar with H4s and H4EADs are getting delayed due to biometric appointments, many Indians will lose their jobs. Do you have, attorney has any suggestions to overcome this problem?
I think one of the most popular questions and often asked questions is about this H4 delays, H4EAD delays. Every segment, we have at least a few questions on this topic, and unfortunately, there is nothing that can be done other than litigation. And I've been saying that if you have tried everything else and it has not worked, don't hesitate to litigate, because you can file a mandamus claim. Mandamus claims are pretty easy. If it is beyond the processing time, you can file it, and you can force USCIS to act upon the benefit that they're required to give you, that they're supposed to give you, that you're paid money for. So file a mandamus claim. I'm hoping something will come up with the already existing litigation that's going on. But for individual cases, you should just file mandamus claims. And if anyone is interested, they can talk to me offline on this.
Yeah, attorney's private consultation number and email are on the screen, and you can reach out to attorney if you need to file mandamus petition. And we have another caller from California. Let's take this caller. Hi.
Hi, my name is Shekhar. I'm calling from California. I have a question to Prashanti Garu. Hello, Prashanti Garu.
Hello, Andy.
Hello, Andy. So my question is, I'm currently a full-time employee, and I have 140 approved. I'm on a 3-year extension after 140 approval with the current company. Now my question is, if I change a role within the company, within the full-time company, like let's say I moved from California to another state for a job change within the company, does it trigger new LCA, new I-140 and this whole process, and is this advisable to do that during this time?
So if you're moving if you're moving to a different county, if your job is moving to a different county, then new LCA is required. An amendment is required unless the county is within the same, what we call Metropolitan Statistical Area, MSA. So you have to check whether it's within the same MSA. If it's not, then you have to file a new LCA, and then you have to file an amended petition. So yes, you have to. But with reference to your green card, your I-140 immigrant petition application, the way they file it is usually in the application they will say that you'll be working at different client sites, and as per the DOL regulation, if you're going to be working at different client sites, then you don't file it. You don't show the workplace as your present client site. You will show the workplace as your company's office address. So that's how we always file it, from the company's office address. And as per DOL, it's a well-established rule from Department of Labor that if the person is going to be working at several unknown work sites, then all the advertising and everything has to be done from the employer's address. So it doesn't affect you then that you're changing work sites. Your green card is still valid. But for the H1, yes, you have to file an amendment.
Yeah, they did that similar thing to me. They put my home address in California as one of the primary work location and also one of the corporate office locations. And I travel to customer places for various projects. So they did not tie anything. So now in this case, I would like to come out of this role of going to different customers and be in one office. That way I am like 100% full-time dedicated to a company without even interacting with the customers. So that's where I'm saying, okay, if the company filed with a corporate office as my green card LCA, then green card wise I am good, but on a H1 basis I have to file whatever amendment. And I mean, my question was, during this time when the delays are happening, is it okay? I have 797 approved for 3 years. Even if it takes 1 year delay, if I go to stamping, then only I get affected, right? Otherwise, as long as when I stay inside the US, and if the H1 change or whatever amendment is pending, I'm still okay, right?
No, you're not okay. You're violating the regulation, no? So that can affect you at any time, even when you're filing a transfer, when you file an extension. If you don't file the amendment of time on time, you are violating your status, and that's a huge problem. It's not okay. So if right now, since you're working remote, right now, let me just clarify one thing.
Sure.
Right now, if you're working remote and if you're LCA, if you're working from your house, because everybody's working from their home, and your home is located within the MSA of the client work location for which your LCA was approved, you're still fine. You don't have to file an amendment. And then tomorrow, if you're working for a different client, but you're still working at your home, you don't have to file an amendment because the work location is your home and that hasn't changed. But when you start working at the actual client site, once COVID-19 is over, then you have to file an amendment.
Okay. So if I, my primary question was, if I change the state, let's say my corporate office, they want me to move to a different location, and then if I change it, then obviously I have to file the LCA and amendment to 140. So that's what I got
correct.
it. But what
not,
I'm saying was,
not 140, please, you're not understanding. Not on 140, just the H1 amendment you have to file.
Okay. So when I apply for H1, apply for it, and then I get a receipt, then I can go and work on that new location.
Yes,
right? I'm
can.
Not saying I won't
Absolutely.
apply.
You don't have to wait for approval.
Right. So even because my worry is because of the USCIS people are less, the workforce is reduced. I mean, my only risk I see is it might take a year or 6 months to get that approved. But once I get a receipt, I can go to the new location and keep working. But if I have to travel outside, then only problem because I don't have stamping. But other than that, as long as I stay inside the country and continue working with that new receipt number, then I should be fine.
That's correct.
Shekhar, there is also a premium option, so which you can use a premium option for amendment, I believe, right, attorney?
Yeah, you can file if you want to convert to premium processing. You can, in case you want to travel at some point in the future.
Yeah, I mean, looks like the caller is worried that it may take a year. It won't take a year if you are filing in premium. So if you want worry-free and all, then you could do that. Okay, another question a lot of people had is what happens when you leave the country when a petition is pending. It could be an extension, it could be an amendment, it could be a change of status. What happens when extension or amendment or any other petition is pending and you leave the country? Is it called abandonment, and what happens? It will be denied, or there will be an RFE, or nothing happens? They can go and come back before the application is adjudicated.
So it depends on what kind of application they're filing. If it's a change of status application, and if you leave the country while the change of status application is pending, then you are considered to have abandoned your change of status request. So there are two parts to that H1. One is just the H1, and the other is the change of status request that you have given. So the H1 will get approved without an I-94. The change of status will get denied. So you'll get a H1 approval without an I-94. You have to go outside the country, get a visa and come back in, or if you already have a visa, come back in with a fresh I-94 because you won't be given an I-94. On the other hand, if it is an approval or a transfer or an extension of a H1, then it's not an issue. There is no abandonment of the petition. The H1 has to get approved, and also they should allow you in based on the receipt of the H1 that you filed. So, that's what it is.
I mean, even they don't have a visa stamp or validity, they can enter on receipt, you mean?
No, obviously you need a visa.
Visa, yeah.
Only if you have a visa. I mean, for example, if you're filing a transfer, you'll already have a visa from your previous company. So it's only in an extension situation you may not have a visa. But in a transfer situation, amendment situation, you can travel and come back on the same visa.
Okay, we have a caller. Okay, yes, got it. We have a caller from Minneapolis. Let's take the caller. I think his name is Ashish. Hi, welcome to the show.
Hi. Thank you.
Yeah, you can ask your question. Attorney is here.
Yeah, sure. Hi, Prashanti. So the question
Hello.
is, I have my change of status approved in the recent times. So am I eligible to apply for consular visa processing?
Your change of status has not been approved?
No, it has been approved recently.
Okay. So then why do you need to do consular? Can you explain your question further?
No.
Yeah.
I'm asking if I'm eligible to go for consular
The visa.
stamping.
Oh, okay.
Yeah.
You're eligible. Yes, you're eligible. You're not subject to the presidential proclamation. You can get a H1 and visa and come back in. The only problem is the consulates are closed in India, so you'll have to go elsewhere, wherever the consulates are open.
Oh, so are we allowed to go to any other country for visa stamping other than the home country and Canada?
Yeah, you can go. You can go and wherever you want. You can go to Canada, Mexico, wherever is convenient.
Okay.
Only thing is you have to remember when you go into that country, with reference to COVID, we have to figure out what the rules are, and maybe you need to quarantine. So you have to find out all that information before.
Sure. But I think on August 17th, they have partially opened the services in India, right?
I believe some consulates are issuing emergency visas.
Okay, so
Delhi consulate is one of them. I am not aware if Hyderabad has opened or not. I have no idea. As far as I know, they haven't.
Sure. So my petition wouldn't fall under the emergency category. It is just a regular processing, right?
Emergency category for what? For the visa?
Yeah, for the visa.
Emergency is decided on a case-by-case basis. Why would they automatically decide that there is an emergency unless you tell them what is the emergency? There has to be some reason for the emergency. There's no automatic.
Sure. Okay.
Yeah, nothing is automatic.
Okay. Yeah, sure. Yep, that's all I have. Thank you.
You're welcome.
Yeah, if you follow up from the last question. Can people apply for H4 EAD when they are not in the country?
No, because first of all, you can't apply for H4.
No, let's say EAD. I'm talking about. Let's say they already have an H4 stamp. They just left the country for some reason, and they are planning to come back later after a month, because a lot of people are saying, can we apply EAD when I'm not in the country? I'll be there in like a month or 2 months. I don't want to
Yeah,
waste the
so I
time.
mean, EAD requires biometrics. So if you're not in the country, you cannot do biometrics. So your case will not be processed further.
EAD requires
You'll get denied.
biometrics. I think only H4
Yeah.
requires biometrics, right?
H4 EAD also requires biometrics. That has always been there. H4 biometrics is new, but H4 EAD has always required biometrics. So only thing is, if it's an extension, they may not require biometrics as per the new COVID rules. But otherwise, yeah. So if it's an extension, they could possibly file from outside the country. Obviously, you have to file to the USCIS here. You cannot file at the consulate. So your signed form has to go to USCIS. So if you can manage the logistics of it. The question might be, though, Ranjit, as to what is their status. In order for them to get a H4 EAD, they have to show that they're presently on H4 status.
Yeah, what I was asking is, they are already on H4, but they just left the country for some reason.
Right.
Let's assume. And
if they have left the country, then they're not on H4. You see?
Yeah, that's what the question is. When they are not in the country, when you fill an EAD form, you have to use the I-94
You have to show that you're presently on a H4, and you may not be able to do that if you're outside the country. They might say that it's an intermittent absence, so they might still consider you to be on H4, but I don't know how they're going to process those applications. Most probably you can't do it, but again, you don't know with COVID. There's no harm in trying.
Sounds good. Okay, another question that we have from a lot of viewers is, what are the requirements of EB1, EB2, and EB3 visa categories? A lot of people say a lot of things, EB1, EB2, especially EB2 and EB3, there should be a set number of years of experience and a set number of years of degree, let's say 4 years of bachelor degree, or some people have only 3 years of bachelor degree. And how do the USCIS or Department of Labor consider this degree requirement and experience requirement for EB1, 2, and 3?
So this is, I'll answer briefly, or at least as much as I can until we get the next caller, because it's a huge topic to cover. But just restricting it to EB2 and EB3 to start off with, because there's no degree requirement for EB1 as such. EB1 is a completely different category with different requirements. So EB2 and EB3 is, there are two types, skilled and unskilled. So the skilled worker category requires a bachelor's degree. The unskilled workers category in EB3 doesn't require a degree, so it can just be work experience, like a cook or a housekeeper, or somebody like that could file, a chef, any position that doesn't require a degree. And the skilled worker category under EB3 requires a degree, so it's a bachelor's degree. It has to be a 4 years bachelor's degree. So the degrees that are in the US, unless it's an engineering degree, if you have a BSc, BCom, they're 3-year degrees. So they're not considered to be bachelor's degrees. So you would not qualify for, an EB3 skilled worker under that category. But the good thing is, whether you say you're skilled or unskilled under EB3, right now the priority dates are the same. So it doesn't really make any difference whether you file with a degree or without a degree. So oftentimes for people who have Indian degrees like BCom or BSc, computer science or something like that, I just ask either for an associate's degree, because a BCom is equal to at least an associate's degree, or I just ask for experience. I ask for 2 years, 3 years of experience, depending on what kind of job it is, what level job it is, seniority wise. So for an EB2, on the other hand, you require an advanced degree. So an advanced degree either could be a professional degree, like a doctor, a lawyer, These are all professional degrees. Or advanced degree could be a PhD degree, or it could be a master's degree. That is a US master's or the equivalent of a US master's or foreign degree. Foreign degree master's is basically 4 years of undergrad and then after that completion of a master's degree. So for example, an MBA degree in India is a master's degree, but it's usually done after completion of a 3-year degree. So there's not enough number of years of education. 14 years of education is not there. So if the person has an India MBA degree and you ask for a master's, an MBA in your labor cert, that labor cert will not get approved, or the labor cert might get approved. The I-140 will not get approved because they'll say that he doesn't have the equivalent of a master's in the US. Because an MBA from India is equivalent to only a BBA in the US. So it's important that you first understand what degree it is and get a credential evaluation done of your degree, and then proceed with your labor cert. Otherwise, you're wasting so much time. We have wasted a year and a half if the I-140 gets approved, because by the time the labor and everything is processed. So EB2 is advanced degree. So as I said, either a master's degree, US master's or equivalent foreign degree, PhD, professional degree, or a bachelor's degree, a 4-year bachelor's degree plus 5 years of experience. So there's been case law, and then after that there have been USCIS memos which have again and again said that a 4 years bachelor's degree plus 5 years of experience is equivalent to an advanced degree. So even those candidates will fall under EB2, as long as in the ads you mention that an alternative of a master's also will be accepted. Very important. If you don't mention in the ad that bachelor's plus 5 in the alternative masters, you will not, again, there will be a problem with your labor cert, there will be a problem with your I-140. If it's a bachelor's plus 5, you have to mention the alternative masters, that you will accept a master's as well. If it's a master's, you don't have to say that you'll accept a bachelor's plus 5. So this is established through practice, through USCIS memos, through case law, that this has to be, the alternative requirement has to be mentioned if it's bachelor's plus 5. So that is your EB2 in a nutshell. For the EB1, there's many ways of getting an EB1. One is if you're on an L1, and if you've been on an L1 for 1 year, then you don't have to file a labor cert. You qualify directly for an I-140 under the EB1 category as a multinational executive. The other way is EB1 is if you file as a researcher category. Researcher category is if you are doing research, if you have patents, if you have citations, publications, you're presently also working for a research organization. The research is helping, you have to show how research is helping the United States, whether it's in the health field, financial field, whatever field it might be. And you have to show that it is in the national interest of the United States to give you the I-140. So this is basically, again, directly filing I-140. There is no labor cert. And the other EB1 category is national interest waiver. For the national interest waiver, EB1 category, you don't have to have an employer. It's a very high standard, so very difficult to qualify because there's no employer sponsorship, you're self-sponsored. So this is EB1 as well. Exceptional ability category, artists, scientists, businessmen, sports, athletes, sportsmen, any of these people can apply, but they have to
sorry to interrupt you, Prashanti Garu. We have a caller, Mallikarjun from Ohio. Let's take the caller. Hi Mallikarjun, how are you doing? Welcome to the show.
Yeah, hi,
and you can ask your question.
Yeah, thanks so much. Thanks. Hi Prashanti. I have a question regarding my dependent's I-539 extension. Hello.
Yeah, go ahead.
Yeah. So the question is regarding I-539. We had recently asked for extension. By mistake, my organization had submitted 2 times. So what should I be doing right now? So we have 2 different cases received for my dependents regarding I-539.
So you can withdraw one of them. Anyway, USCIS is going to send you a letter saying that you have to which one do you want to keep and which one you want to withdraw. As long as you've got a receipt for both of them, you know that both of them have been accepted. You can make sure that you have submitted all the documents for both cases. You want to keep the stronger case and withdraw the weaker one. So if both are same, then you can just decide which one you want to. You want to keep the earlier one and then withdraw the later one, obviously. But if there's some defect in the earlier one, then maybe you'll decide to keep the later one. So just decide accordingly and withdraw one of them as long as you have receipt for both.
Yeah, both are same. Both are exactly same. By mistake, it submitted two times in a different days. I don't know how to what is the process to withdraw?
Just send them the letter along with the copy of the receipt.
Okay.
That you are wishing to withdraw because you filed in duplicate.
Okay.
And submit the receipt copy of the one that you want to withdraw.
Yeah, I get it. Okay.
Okay, another follow-up question from what callers was asking. So if let's say attorney has filed the H4 petition, so can even the beneficiary can withdraw even though it's filed by an attorney, or
Yeah. Yes. Beneficiary. This is a beneficiary application. It's not an employer application, so employer doesn't have to be involved. With reference to being represented by an attorney in any kind of case, if you want to represent yourself at any point of time, you are not bogged down by the fact that the attorney initially represented you. You can, if you have an RF, for example, you get a H1, the attorney represented you on the H1, you get an RFE, you want to submit the RFE response yourself, you can go ahead and do that in a I-485 or I-539 case. Yes, absolutely.
Okay, going back to our EB2, EB3 thing, let's say I bet the beneficiary has only 3-year degree, but he has, let's say, 10 years or 12 years or a lot of experience. Will they still be eligible for EB2 or EB3 category? Is like experience, certain years of experience counted towards a year of degree, something like that?
So you can't do the, I know what you're talking about, the evaluation, work experience, evaluation that we do for H1s, 3 years of experience is equivalent to 1 year of degree. That is done in a H1B scenario, but in the labor cert scenario, they don't accept that kind of 3 years equivalent to 1 year, because in the labor cert, they're very clear as to what is needed. EB3, it has to be a 4-year bachelor's degree if it's EB3 skilled. Unskilled, it can be just work experience. And as I said, there's no difference between the two. They're both EB3 and both have same priority dates. EB2 has to be an advanced degree, and I've explained what an advanced degree is. So yeah, you can't necessarily substitute work experience for and make it equivalent to a bachelor's in the labor cert process.
Okay, got it. So another EB1 category that you were talking about is L1, you said. Is it for both L1A and L1B, or is it only for L1A?
Right, good question. For the L1A, it's L1A is multinational executive. L1B is specialty occupation. So L1Bs are more like H1s, where you have to file a labor cert, and it falls under EB2. It doesn't fall under EB1. L1A is multinational executive, so only in each company you can't have hundreds of L1As. You can only have a few. The top management, the executives, the people who supervise other people, who take policy decisions. Those are the L1As. So those are EB1s. L1Bs are not.
So they can directly file I-140. And do they have the premium option in the I-140? They can directly do it and then...
Yeah, right now premium is available for I-140s, yes.
Another question I had is, a lot of people say that national interest waiver, I-140s, doesn't have a premium. Is it true?
As far as I know, NIW, we can look it up because I haven't looked it up recently because it keeps changing every time. So I haven't looked it up recently, but I believe that all EB1 I-140s have premium processing, but I may be wrong. I haven't looked it up recently.
Okay, sounds good. Okay, another question that a lot of employees have is multiple H1Bs allowed? Like, how many H1Bs can an employee have and work for multiple employers? I have like few questions on this, so let's go one by one. So is it allowed, like, let's say I can have two H1B approvals from two different companies, and can I work for both at a time? Any restrictions?
So it depends on how you have filed the H1. If you have filed the second H1 as so you can't file it as a change of status or a transfer. Right?
Concurrent filing, right?
If you filed as a concurrent H1, then you can work for 2 employees at the same time. You can work for 3 employees at the same time. It all depends on how many hours in a week you can work, because you have to sleep also. So it has to make sense to the officer. So if, for example, if you work 40 hours and 40 hours, that's possible. You can work 80 hours a week, some people do. Or you can have one full-time H1 and then you can file a second concurrent H1 for part-time. That's also very doable. So yes, you can have 2 H1s, but you have to make sure you mark the correct column in it and call it concurrent and not transfer.
Yeah, another follow-up question on the same. How many hours of job is considered a full-time? Is it 30 hours or 40 hours? Because, there is a lot of, when you Google, it says 30 hours is considered a full-time. So is it like, do we have any particular set number of hours in terms of USCIS?
Yeah, so USCIS doesn't follow any hard and fast rule. Usually it's 40 hours, but even 35 hours would be considered full-time. And I think if you go anywhere below 30 hours, you should file it as a part-time H1. And then it's really not part-time or full-time, you just file it on an hourly basis, so they can, depending on the number of hours they're working. And by filing it on an hourly basis, you also have more flexibility. So the prevailing wage is defined per hour. It's not really defined as an annual salary. And then you just mark it as part-time, and then, you can work maybe 5 hours one week, maybe 10 hours the next week. So you'll have that flexibility.
Got it. So another question is, so does H1B has to be a full-time, or let's say a guy has only one H1B, can that be a part-time H1B?
It doesn't have to be full-time. That's a good question also. In order to maintain status, as long as you're able to not be a public judge, right? You can have a part-time H1 as well and still maintain your status, get a visa, do whatever you need to do.
Got it. Sounds good. So in this case, people can have multiple H1Bs. They can do one full-time or multiple part-times or whatever it is, as per, the number of hours that is really possible in real world. That's good to know, because a lot of people have these questions, like, people say that you cannot do more than one job. But it's not like that. You can do as long as it is filed properly, and especially the second H1 should be filed as a concurrent H1B, which is checked on the LCA as well as I-129, right?
Mm-hmm. That's correct.
That sounds good. So, especially in these COVID times, this is a good time for people, especially if they want to work multiple jobs. Now it's remote.
Or if you want to, you're losing your job and they're offering you only part-time, and therefore you need to amend your petition to part-time.
Yeah, that's also a good thing. Rather than losing a job, you at least tend to keep it a part-time job.
Right.
Sounds good. That was very informative. Okay, another question. Well, while we are talking about this evaluation and all, is education evaluation mandatory, especially in terms of the H1B, especially when people doesn't have an IT degree? A lot of people come from electronics, mechanical backgrounds as well into IT. They have IT experience, but then they don't have a degree. So in these cases, do you prefer having an educational evaluation when filing an H1B to make things easier? Or, it really doesn't matter when the beneficiary has IT experience, especially?
So usually what we do in our office, we don't do an evaluation for every single case just because it's a foreign degree, because we don't like to waste the employer's money. So we only do what is necessary. And in our years of practice and experience, we know what is needed and what is not. So usually what I do is, if it's a straightforward bachelor's degree in computer science from India, I never do the evaluation. It's, very rarely do they send an RFA asking for an evaluation of that degree. They all know that it's an engineering degree. As long as we see that it's from a recognized institution, I take that call, and I usually don't send out evaluations. But as you said, if it's an electronics engineering degree, then at least in present times, in the past, we never used to do it because it was understood and recognized by USCIS that an electronics engineering degree also person also qualifies for an IT job. But recently, they have been making a fuss, and they have been objecting to that. So what we've been doing the last few years is, if it's an electronics or mechanical or any other field other than computer science or information systems or information technology or something related to computer science, we get a work experience evaluation done. So that, and as we were talking about work experience evaluation, the way they do it is they equate 3 years of work experience to be equal to 1 year of college education. So that 1 year of college education in IT is able to give them a major in computer science or in information systems, most probably in information systems. So the evaluator is able to give them the equivalent of a bachelor's degree in information systems, and that is sufficient for our H1 purposes. But sometimes even if we get that done, they send an RFE back, and then we have to get an expert opinion evaluation, which is a step higher and costs more money, but they want it directly from a professor. And then there's a more detailed explanation in the expert opinion letter. So we get that done as well, sometimes as needed. So either an educational, simple work experience eval or an expert opinion letter would be needed. So that's what we do with reference to evals. And of course, then if you have a US degree, you don't need an eval. You can't do an evaluation of a US degree. Nobody will do it. So
it would be same for even people who has like a 3-year bachelor degree, but then they have more experience, so they'll get an evaluation for 4-year degree equivalent. So that's also another case when you
correct. That's another way. And the other thing is, we get an evaluation done is, suppose the person has an electronics engineering degree, but he doesn't have 3 years of experience, maybe only has 1 year of experience because he's a fresh graduate. In that case, then we do something called course mapping, and instead of the attorneys doing it or asking the client to do it, we get it from the expert. We get an expert opinion evaluation showing how the degree is related to the job at hand. And that, when they say it, it works better than if we say it. So that's why we get it done. Not that we can't do it. We know how to do it, but it's more convincing to USCIS when they say it. So
coming from a professor.
From the professor. So we get that done as well.
Okay, sounds good. Okay, and other question a lot of people have is regarding the EB2, EB3 downgrades. So now that, if you had a look at this visa bulletin, there was no movement in EB2 and EB3. But then for the past few visa bulletins, there's a lot of movement in EB3. So especially people who are on the borderline, is there a possibility that you do an EB2 to EB3 downgrade without having to go through all the labor process, because which again takes a year or more than that? That doesn't make any sense again. So is there any way who already has an I-140 in EB2, let's say the EB3 gets current for them, is there any way that they amend or do something and downgrade to EB3, get the green card or EAD, whatever, on time?
Yeah, that's definitely a possibility. As you said, it doesn't make sense to go through the entire labor cert process again, simply because time is of the essence, and that priority date may not remain current. But if you do an I-140 amendment and you do it in premium processing, then it's possible that you might catch that wave of, the priority dates becoming, more advanced. You might be able to catch that wave. Often it's a struggle for people to decide whether to do it, not to do it, because they don't know for how long the EB3 will remain current, whether EB2 will overtake EB3. So, the best way to decide is to look at these updates given by Charlie Oppenheim, and he usually gives some kind of prediction on what to expect for EB3s India, what to expect for EB2s, and then make a decision. A lot of people have two I-140s, one EB3 and one EB2. So if you don't amend it, and you actually file another I-140, then it's possible that you can keep both I-140s and then decide which one to use. So that's also another thing to think about.
Sounds good. At least they have an option that if the dates get current or whatever, they have this option of going to.
They can revert back to the previous I-140 and ask that file the I-485 on the basis of the previous I-140.
Sounds good. So another thing that's in buzz in all the media is that USCIS is going to furlough 13,000 employees, which is about 75% of the workforce. So I believe it's going to happen by the end of August unless there is some funding or USCIS changes the mind. But then do you think it will be a huge impact, and what do you suggest the employees or employers to keep in mind? And if something is due, how do you think they should proceed? Like, say, maybe there won't be any premium. That a lot of things could happen. So any suggestions for viewers, employees, employers, if that thing is going to happen, how to make sure you get everything on time?
So yes, it's a very real possibility, because as time is as the deadline is coming closer and closer and nothing seems to be happening, we have to keep in mind that possibility that there may be a furlough. The latest update is that USCIS does have enough money to sustain itself until the end of this year, but they will not have a cushion. So they want to keep that cushion. Therefore, they want to continue the furlough even though they don't need to right now. There has been some activity in the House. There have been congressmen writing to USCIS. Recently, a congressman wrote to, I forget his name, but he wrote to USCIS. Do you know the name?
Patrick Lee.
Patrick Lee. That he wrote to USCIS and asked for the furlough to be stopped, or for USCIS not to furlough employees because there is enough revenue right now. But we don't know what will happen, and so we have to be prepared. And as it is, the backlogs are pretty bad. You've seen what is happening with H4 EAD. I can't imagine what will happen with the backlogs if they furlough 75% of the employees. I mean, people will keep filing because they have to file, but they will not get a response for a long, long period of time because it'll just keep building up. The backlogs will keep building up. So there has been some speculation that premium processing will still exist because they need money. If it does, then obviously everyone has to use premium processing, otherwise they will never see their case until the next year. So, I mean, premium processing would be then a big, important tool to use. I really don't know how they're going to use premium processing. If everybody files in premium processing, they won't be able to do it because they don't have employees. So I'm not quite sure how that will work. But that's what we've heard, that they will try and continue premium processing. The other way is to just do the expedited requests. That is always a tool that we have. Ask for USCIS to expedite cases based on whatever emergency we have. There's no harm in asking. Will they do it? We don't know. In some cases they might, some cases they might not. So that's another tool to keep in mind, the expedited request, and of course then do everything premium processing. Other than that, there's not much we can do other than writing to our congressmen and our legislatures, asking them to, pass some kind of a benefit package or force USCIS not to furlough their employees. Something has to happen. Somebody has to give in.
Or just automatically extend every petition.
Yeah, that'll be nice if they just approve every petition without anybody reviewing it.
Just like they did driving licenses in COVID situation, a lot of states automatically extended for 3 months, 4 months, and 6 months.
Right, at least temporary extensions if they can grant.
That sounds like a good idea, but let's see how what's going to happen with the USCIS.
Right.
And other thing, a lot of buzz that's going around is now the end of the fiscal year is coming up, and because of this travel ban, COVID, and other lot of diversity visas or whatever other reasons, a lot of green cards went unused. And according to Department of State, I was reading something, and there is about 100,000 or 110,000 of green cards that are unused, which will eventually roll over to the employment based in the next visa bulletin. What do you think? Do you have any assumption or anything that at least there is a light at the end of the tunnel for EB2 or EB3 to move at least few months or so? Because always it has been, at least for the EB2, there was only a day's movement every visa bulletin. At least from the last 8 years, I believe it's only 3 or 4 months of movement.
Yeah, EB2, there might be less movement. I don't think there'll be a significant movement, but EB3, there might be better movement on EB3. That's what we heard. But even a few months makes a huge difference, because a lot of people are waiting on that cusp, on the edge, for their priority dates to become current. So even a few months is thousands of applications that can be filed, right? So especially during that time period, because a lot of people have been waiting since that, and in that borderline time period. And also the date.
Sorry to interrupt you, Prashant. We have a last caller, Shailesh from LA. Let's take the caller. Hi, Shailesh. How are you doing? Welcome to the show, and you can ask your question. Attorney is here to answer.
Hi. Hello, Prashanti.
Hi.
This is Shailesh from LA. I just wanted to check with you that I had applied H4 and H4 EAD for my wife in February and Feb 4th. It's been more than 6.5 months now. So no update on the approval or rejection on that case. In online, it just says name was updated. That's all.
Okay.
So I just wanted to check, like, is there any actions that we could take now with USCIS in order to expedite, or?
So what is the processing time as per the USCIS website? Did you check for your case? What is the projected processing time? What are they saying?
It's 4.5 to 6.5 months.
Right. So once you pass that 6.5 months, file a mandamus application with federal court. That's the only way. I mean, that's not going to be instantaneous, but unless something happens with the H4s and H4 EADs, it looks like they are not going to prioritize them. Maybe even it's an intentional thing to put H4 and H4 EADs on the back burner, because it seems that they're processing all other cases like they should. Why are they only not processing the I-539 applications? They're processing the H1s, even the ones that are not premium processing. So it seems like some kind of a strategical move on their part not to give H4s, their EADs, especially the delays for H4 EADs. So I would, file. The only way to do this is either ask them to expedite it, tell them, give them a reason, and send in a letter and see what happens. Say you're going to lose the job or whatever it is. But there are thousands of people like that. So I don't know if that will really be effective, and then you'll be losing more time because they don't respond immediately. They'll say, okay, wait for 60 days, and then they'll send a response saying, sorry, we can't expedite. So instead of that,
Shailesh, I think, we have another caller. So let's take the last caller. We are at the end of the show. Thanks for calling. We have another caller, Neeta. Let's take the call, and this will be the last call. I think we are at the end of the show. Hi, Neeta. Welcome to the show. Please ask your question.
Yeah. Hi, this is Neeta calling from Kansas. Good evening, Prashanti. I have a question regarding the I-140. Okay, so I do have an approved I-140 from my previous employer, right, which got approved almost like 3 years ago. Now it is that I have switched to employer B, who is planning to file the entire process, the GC process, all over again. Is it the right way of doing things, and is there anything that I could be exempted since I have an approved I-140?
Unfortunately, that is the right way of doing it. If you're moving employers, then the new employer has to file a new labor cert. The only benefit, of course, that you can retain from your previous I-140 is the priority date. So you get to retain the priority date. When you file the I-140, make sure you tell them that you have a previous I-140, so they will attach the previous I-140 approval and ask for the I-140, a new I-140 for the priority date to be retained. But otherwise, yes, you have to unfortunately file the labor cert again.
In due course of time, is there a possibility that employer A can go ahead and cancel my existing approved I-140?
Yes, he can, but that will not affect you, and that does not affect your ability to keep your old priority date.
Thank you. Thank you for valuable information.
You're welcome.
Yeah, thanks for the call. I think we are at the end of the show. Before we close, I have one question, Prashanti. Could you please let us know if people want to do litigation, how do they approach you, or are you is any process that that should be followed?
Just send me an email. Email is the best way of contacting me. My email address is there. So the best way is send me an email. Tell me what your situation is, and I will let you know whether it's a good step or not. It's not for everyone. It depends on your particular situation. We will only do it if it's necessary. And every case is different, right? The need is different in every case. So
yeah, if everyone here, if anyone wants to reach out to the attorney Prashanti for private consultations, you can reach her at 212-354-1010 or prashanti@reddyesq.com. If you want to be the process of mandamus or any litigation, please reach her and she would be able to assist you with that. I think we are at the end of the show. Thanks for all the calls and watching the show. It was a great session with interesting topics and FAQs today. Please call in every Wednesday at 6 p.m. EST to watch the Immigration Talk Show. Again, it's every Wednesday, 6 p.m. EST and Sakshi TV. This is Ranjit signing off. Thanks, Prashanti.
Thank you, Ranjit.
Bye-bye.